Hello, welcome to Mentoring with the Masters. My name is Jennifer Kuyrkendall. I'm the Third Circuit representative for the Young Lawyers Division Board of Governors. In this video, you're going to be hearing from Rebecca Palmer, who heads the marital and family law practice at Lowndes, Drosdick, Doster, Kantor Reed. In this first video of a three-part family law series, Rebecca is going to be speaking with you about parenting plans.
Hello, I appreciate you watching this video today. I'm going to be talking about family law cases. In particular, I'm going to address the acronym PEACE. When you're doing a family law case, that's the way to address it. You start off with P for parenting, E for equitable distribution, A for alimony, C for child support, and E for everything else, like attorney's fees. The reason you go in that order is because each one of those items affects the other. For example, in parenting, if there's a 50-50 time-sharing arrangement, that will change the child support. That's why you go in that order. So I'll do a series of 3 videos for you, and the first one is going to be specifically about the parenting portion, or the P of PEACE. In the parenting, what you want to look for ultimately with your clients, first and foremost, I think it's a good idea, if at all possible, to try to settle the case. When you have children involved, it gets so emotional. And if the parents can work together to resolve that, that is tremendous. And there's things that you can do to help your client get to that resolution. Sometimes that includes the attorneys stepping back and sending the clients to a counselor to try to work out their differences. The ultimate goal, whether in resolution or through litigation, is to get what's called a parenting plan. Now, on the money side of things, you enter into what's called a marital settlement agreement. But on parenting, you enter into what's called, or you'll have ordered, a parenting plan. Let me talk to you about some tools in dealing with parenting issues. I call them tools. They're really individuals and different things that you can do when trying to sort out children issues. One tool, as I call it, is called a guardian ad litem, a GAL mostly referred to. If you have a struggle between two parents and they cannot make a determination and you feel as though you need someone to be the voice of the children, to interview the children and others, I recommend you consider hiring a guardian ad litem. That's someone court appointed, perhaps suggested by you and or opposing counsel, or appointed via a motion to appoint a guardian ad litem. The guardian ad litem is really unique. They can do things that really nobody else can do. Talking directly to the kids, talking to their teachers. If you do decide to hire a guardian ad litem, I suggest to do a lot of homework beforehand. Before hiring that guardian ad litem, prepare what you want to give to them. Remember, it's discoverable though. Anything you give to the guardian ad litem may come into evidence, so keep that in mind. But in giving your guardian ad litem information ahead of time, background, photographs, your side of the story, that can help the guardian ad litem a long way. You want to be informative to the guardian ad litem. You also want to give them names. Here's who I think you should talk to. Talk to this religious leader of the children. Talk to this teacher of the children. Talk to this neighbor. And again, that guardian ad litem will have insight that really nobody else can gain. I've done this before, and even in international relocation cases that I've had, and found them to be invaluable. In that regard, sometimes the guardian ad litem has to travel. For example, one of my clients was looking to relocate to London, England. She, the children, and the father had always lived here. The guardian ad litem actually went to London to go see where the children would live. That's a unique opportunity that the court would not otherwise have, to see and hear through the guardian ad litem's pictures and words what it would look like in London, and we were ultimately successful actually in that case. Another tool, as I call it, is a parent coordinator. That's another expert that can help you in the ultimate goal of getting to a parenting plan. The parent coordinator can assist the parties when they have disputes, and you can have a parent coordinating order which guides them on what they can do. If you decide to hire a parent coordinator, make sure to call that counselor ahead of time and ask if they have a specific order that they usually use. If they do, that can be helpful for you from the bat to use. You don't want to use one from scratch necessarily that their office normally doesn't use. Some counselors don't have one. At that point in time, look for some good forms and then present that to the court for acceptance. Hopefully, opposing counsel will agree with you if you decide to go that route. Another tool, as I call it, is a parent counselor. That's a different role. A parent counselor is someone if the parties are just really having a hard time communicating. Actually, today, I had a former client call me. She and her ex-husband were having a dispute about the children and the way things that were going. Luckily, in their parenting plan, there was an agreement that should they have such type of fights, that they would in fact go back to a parent counselor before even going to mediation or in fact going to court. I think that's a good plan. This has happened before with that particular couple. Got a call about a year ago, never even went to mediation or to the court. They were able to resolve it with the counselors. So something to consider in your agreements. Something else to consider is hire a psychologist for what's called a parenting plan assessment. That's different. That is a different tool, as I'm calling them. A parenting plan assessment is where there is a battery of psychological tests given to both parties, and they are interviewed, and potentially there's an opportunity for play in front of the counselor to see what the interaction is like between the parent and child. That is something, too, you might want to consider, a parenting plan assessment. They take time. So be ready to know that you're not going to have your clients go 1 week and get an answer the second week. Like the guardian ad litem, I do suggest that you provide information to the counselor prior to the parenting plan assessment, knowing again, this is an expert and whatever you give them is discoverable. If you do want to see what the other side gave them and you're taking the deposition of the parent plan assessment counselor, make sure to do a deposition ducus tecum, seeking their records, making sure you get to see all the documents that they were provided. Ultimately, once that's completed, you'll receive what's called a parenting plan assessment. And that assessment will suggest, more likely than not, what the schedule should be, whether one parent should spend more time with the children, concerns, and the like. I often find that even if you're gearing up for litigation and you get a parenting plan assessment that is very strong for one side or the other, that's a ripe opportunity to settle. If you have that happen, I would suggest to try to do a mediation before court if the parenting plan assessment seems fairly and well done in such a way that the parents are willing to potentially follow it. There's been a lot of changes in regarding to parenting. When you have clients come to you, you may hear antiquated words. They'll talk to you about things like, I want to be the primary residential parent. I don't want to be the secondary residential parent. Those type of things are now antiquated. Quite frankly, we become more politically correct when it comes to parenting. When I started practicing over 20 years ago, not to be sexist at all, but mothers had more time with the children. That has changed dramatically. It is very often that you now see a 50-50 time arrangement. When I began, 50-50 time arrangements were frowned upon, and some judges were reluctant, even if the parties agreed, to enter it. That has completely changed. A 50-50 arrangement now is very common to find. So let's talk about that. If you are in a situation where the parents want to equally timeshare, that's 50-50 with the children, think about several things. One thing you need to think about is the age of the children. If they are 3, 4, or under, there are psychological studies that say that they should not go more than 2, 3, maybe 4 max days without seeing the other parent. There's significant bonding going on at a very infant and young toddler stage that they should not go long periods without seeing the other parent. So when considering a 50-50 design, take in not only the parent schedules would absolutely have to be considered to make it work, but very importantly, take into consideration the age, the specific personality of the child, and those type of things. Some children do great in a 50-50 arrangement. Others suffer. So you have to consider that. If you have older children, a week on, week off is an excellent arrangement for many children because they don't need to see mom or dad every day. They know mom and dad love them and that they're there. You can arrange Skyping, telephone calls, and I encourage that when one parent is not with the other to make sure there's other contact that's occurring. At a certain age, too, they're going to be in sports or ballet or gymnastics, so there's opportunities there for both parents to have an opportunity to see their children at their activities. So 50-50 is more and more common, but there's something I want to talk about that in particular. If you do decide and have your clients enter into that week on, week off opportunity, I suggest what's called a natural transition. What that means? Natural transitions mean Don't have it be from like a Tuesday to a Tuesday and pick up and drop off for mom and dad's home. Couple problems there. You have an opportunity of a lot of stress if they're dropping off at one another's home. It's almost like a forced moment. Whereas if you chose something like a Friday to Friday, which is what I suggest, Fridays are happy days. They're starting the weekend, usually much better for people. So Friday is way less stressful. A lot of people do Monday to Monday, and I find the people doing Friday to Friday, Friday on, Friday off is better. And the natural transition is this. It's better to have one parent drop the child off at school, and then the other parent pick the child up from school. That's natural, or their designated driver. That's a better way to do it instead of a forced, it's Sunday night, I'm here, I'm home, here's my luggage. Awkward, we have to see each other. Maybe one of the ex-spouses, has someone over, and so that can be awkward. So I do encourage natural transitions, not forced meeting at a restaurant or even one another's home, unless there's a really close relationship between the exes. Please consider that. When you go through parenting, one of the mistakes I find that a lot of lawyers make is they avoid looking at the law. That sounds silly and simple, but it's really true. What judges need and want to hear when you're in trial, let's say you're unable to resolve it through all these methods and you have to go to trial, what you need to do at that point in time is to look at the statute, Florida Statute 61.13. If you look through the statute, my recommendation is in closing argument, while tedious, I have found it very successful, and really what the court needs to hear is for you to go through every factor. So looking a little bit about that, it starts out for purposes of establishing the parenting plan and continues in that paragraph, and then it goes through the factors. For example, we'd want to say to the court, Factor A, Your Honor, the demonstrated capacity and disposition of each parent to facilitate and encourage a close and continuing parent-child relationship, to honor the time-sharing schedule, and to be reasonable when changes are required. Then you would state your position, why your client is continually working with the other side, and why they're very flexible, and why they're sending photographs of the child at sports and the like. So you'd walk through each factor and make the argument why your client is a better parent as to that factor than the other side. That helps the court tremendously. I often actually draft my final judgment before I ever walk in the courtroom. That way, I know exactly what I need to put into evidence, and I know what I need to say in my closing argument. So there are many more factors, so make sure to look at the statute and go through each of those. And looking at those factors, and as you build up to potentially trial or mediation for that matter, there's a couple of social media things I want to make sure that you're thinking about. We all know the world of Facebook, Twitter, Instagram, and the like. Well, guess what? That's tremendous evidence. I saw yesterday, I have not checked the accuracy of this, but on the internet it said there's been a study that 1/3 of all divorces somehow touch Facebook, whether it's through an affair, whether it's what they've posted, but it's amazing to me. Social media is a huge deal. You need to have a dialogue with your clients about this. If they have these type of accounts, they need to make sure they're careful what they say on Twitter, what they put on Instagram. I have literally seen cases won and lost by those type of things. So tell them to be smart about it. It is the internet. Same thing with text and emails. That's evidence. If you've got a client sending nasty emails to the other side and you don't know it, and they come in with a pile of evidence of these emails or texts about everything your client's been saying, you got a problem. So make sure to talk to your clients too and how they communicate with the other parent. It's really important, not only for evidence, but for life, frankly. Another suggestion I make for my clients, both during potentially a case and even afterwards, is to have a simple 30-day calendar. Tell them to get a 30-day calendar, and on that calendar to simply jot down, Mom didn't show up for contact today, or Dad yelled at the kids and the kids cried for 30 minutes. Whatever it is, keep evidence at that point in time building up to the case. A whole diary is too hard. Diary, you get on the stand, you can't find the right pages, but an easy 30-day calendar is easier. After either litigation or an agreement, hopefully through mediation or collaborative law, what I suggest to parties is keep a 30-day calendar right on your fridge or your counter or somewhere very visible for the children. And it's really great when both parents share the same calendar. So if the kids are seeing both calendars at both homes, they can see, this is where I'm going today, this is who I need to be with, and this is what the plan is. I find it highly effective for clients, and in particular for the children, so I do recommend those type of calendars. So that's some information regarding parenting. I hope that was helpful for you. Feel free to watch the other videos as well regarding equitable distribution and alimony and child support. Thank you again.